board assembled. Welcome to the ZBA meeting, and it's a continuation of the hearing that we have been having with Firetree as the applicant. I just want to go over the general rules. We'll be dealing just with what's on the agenda tonight, which is Firetree. Now, we normally have a section where the applicant makes a presentation, the public speaks to it, the applicant can have rebuttal, and then we kind of wrap up and move to deliberation. This has moved on longer and longer, and there were questions at the end of the last hearing. So we asked staff to investigate a few things, which they have done, and then if the applicant wants to address it, he can. And if there's something new from the public, there was an item given to us tonight that was new and it's going to be passed down, then we'll accept it. But it has to be new. It can't be a rehash. Even a new rehash. It has to be new. It's something that we didn't know about before. And we're going to try to wrap up tonight. We don't really want this to continue past this evening. With that said, if you guys would, if everybody's got cell phones, if you will do what I'm going to do, turn your cell phone off or to buzz. Especially if anybody has the Star Spangled Banner or something like that. Not great. And then our secretary tonight is Joe Vagan, and Joe will read the item.
17-0628-01 Firetree Limited, special exception to permit a change from a non-conforming use of land or structure to another non-conforming use. Section 118-800C4 and 118-1410A2D in C residence zone, property located at 17 Quintard Avenue, District 2, Block 87, Lot 32, Coastal Area Management. Request. Applicant is requesting a special exception to change one non-conforming use to another.
Mr. McGrain?
Yes. Since we, at our last meeting, you had asked me to look into specifically the BOP procedures for placement of prisoners in residential reentry centers. After quite a bit of effort and I believe the help of a congressman, we were able to get in touch with a few people in the residential reentry management branch. And also the applicant's attorney was nice enough to let me know confirm one of the contacts there. The two contacts were Miss Dana DiGiacomo and John Gustin. Earlier today, Adam Bovelski, the Fair Rent and Human Relations Director, and I spoke to Mr. Gustin on a conference call, and I think it was very helpful. Well, I should back up. First, he sent me an email answering the 3 questions. Has the board seen that?
Have you members seen the email with the 3 questions answered?
Yes.
Okay, good. So first, he was nice enough to answer those 3 questions. Then I asked him if I could have a few minutes of his time for some follow-up.
This is the day that you got it.
This is today that I got this.
Mr. Cody, did you get a copy of this communication that occurred today?
Well, this was verbal communication.
Oh, so obviously you didn't get a copy. Basically what, and Adam, as I said, Adam and I sat in on the conference call, basically what we were looking for was a little more clarification as far as the actual process. So
we understood kind of the ground rules, but we asked Mr. Guston to sort of walk us through the exact process. He had said, I'm taking some notes here, it's basically all prisoners are eligible for transfer to an RRC. We weren't sure if that was limited to, you know, a certain subsection of the prison population. No, all prisoners are eligible. Less than 1%, he said that less than 1% refuse placement. So a very, very, very small few actually refuse placement. It's something, in his words, that they actually look forward to or prefer versus traditional prison life. The two categories of people he gave us that are typically refused by the BOP or that factor into the BOP's refusal for placement are if the prisoners have pending charges or are deportable aliens. They may not be eligible for placement in an RRC. He confirmed that the specific location of the RRC placement is, as the applicant has previously stated, that which is in close proximity to their release residence, the prisoner's release residence, kind of controls. And then we got more specific into the actual disability, and we asked them, does disability factor into the prisoner's placement? And Mr. Gusta basically told us that they are aware to some degree of the prisoner's disability. The RRC, the contractor, is handed off what he considered a condensed medical portfolio for each of the prisoners. They are contractually obligated to provide transportation to or make available off-site medical treatment for whatever they need pertaining to their medical condition or their disability. But outside of that, the major focus of the BOP is the rehab from the institutionalization of that prisoner. So they are not primarily concerned with placing a prisoner so that he or she can have the appropriate congregate living environment. They are concerned with coming up with a time period for placement into an RRC that is commensurate or appropriate for that person's level of institutionalization. The amount of time they feel like that person needs to acclimate back to normal life, home life. He had said that, and this was kind of interesting, maybe Adam can speak a little more to it, that drug and alcohol addiction is not considered a disability from the Bureau of Prisons. The three factors, he had also said none of our facilities are licensed treatment facilities. So, in other words, as I said before, they're not doing any on-site, and I think the applicant said that, but he further explained that none of the facilities are treatment facilities. They get the help that they need off the site. And their primary goals are broken down into three categories. He said employment, housing, and integration of family ties. So that's what they're focused on, that's what they're looking at. outside of that, are they aware of individual disabilities? Well, yeah, they're assessed at the Bureau of Prisons. They're aware of them. They're in their medical portfolio. A condensed version of which is handed off to the RRC, but in large part, that's not part of their factors or their decision-making in placement into an RRC.
Did he give you any indication of whether more than half of the residents in an RRC would be disabled on average?
He made us aware that there are prison demographics that we can find on the BOP's website, but I took a quick look at those, but the prison demographics that I was able to find were the one relative to drug and alcohol was specific to the percentage of inmates that were convicted of a drug and alcohol crime. So obviously that's not, and I believe that was somewhere in the 54% or something like that. But that's not going to help us as far as a specific disability or even evidence of alcoholism or drug addiction, because one can be a drug dealer without being addicted to drugs.
Aileen, did you get a chance to take a look at the costs that we asked about?
We did. I actually did a site inspection with Bill Ireland, who's the chief building official, and together we looked through the entire structure, and based on that inspection, and also a review of all the bills that were submitted by Sablinski Construction, it was my determination, along with Ryan's and Bill Ireland's, that the cost of the structural work was not more than 25% of the value.
How close to the cut?
What did we figure, 70?
You said like 70-something thousand, and I think 90 was the.
90 was the magic
Was it,
number.
reading the material that you sent today, there was questions on just interpreting that. Is it the 25% of the appraised value today, 25% of the appraised value after they bought it, or 25% of actually when they bought it?
25% of pre-construction assessed value, not appraised value.
Assessed value.
Assessed
okay.
value, the difference
So the
is.
assessed value is at $300 and some odd thousand, not the 200 and something that was in some of that material. Wasn't there something on there?
I'm not sure what the exact assessed value was.
Because I think there was something with field card.
I think there was
90
two
times-
that I saw on
90
the
times
field.
four.
One was
Was
just
that 360?
under 300,000, and then the other was 400,000 and change. And I think the 300 was the applicable one. And I think we did the math last time and came up with 90 some odd thousand, 25%.
That's correct.
Institutional memory. Anyway. And I want to make sure the board has their questions answered, so why don't we start with Greg?
It was really that, it was only that one. And because I know that one of the emails we got had outlined 3 different valuations for the home. And I just want to be, I guess, crystal clear on those 3. Do you recall what I was talking about? I think someone out here had submitted something.
They may have submitted something.
The field card, right?
Yeah,
Yeah,
but
the
we
field
had to
card.
go by what we had talked about earlier,
Which is
the whatever that number is of the assessed value of the structure based on the tax assessor's assessment.
okay.
In 2015 too, not the current
Mhm.
assessment.
And remind me, what did they buy the house for originally?
429,000 was the number that's.
Okay.
Yeah,
Other questions?
Joe?
Yeah, I took another look at the question of the upgrades myself. And I know it's close. Some of the prices for some of the items that are in this sheet that was sent from the construction company in the folder. Some of them I thought were kind of high and some of them I thought were kind of low. I mean, I don't think that, we'd have to see actual checks to make sure that those are the accurate prices, but there are contractor costs and stuff built into these prices. But I did find it a little strange that the plumbing, electrical, fire, low voltage, and heating and air conditioning are almost $200,000. But the structural work was $18,000 for interior framing. So that struck me as a bit odd as an electrical contractor myself. But I'm sure that Bill, that's up to the building department and you guys to go through. So that's what I'm going to go with. And I thought that it was close, and it is close. But that answered my questions. The notice that was sent with all of the line item prices for each of the trades.
Thank you. Mr. Stribinger.
Well, I'm still not convinced that we have accurate numbers on the people that were living there when Pivot was there. We've had one testimony from the applicant saying that there was as many as 18. We've had observations from the neighbors, and we've had personal observations, at least when the Pivot people have come to religious services. I'm concerned that the applicant didn't make sufficient effort to bring forth the records from Pivot of the actual numbers of people. They're an ongoing company, they should have had those records.
Can you improve it? Can I ask Taylor just a question on that? Do you mind? I know that one of the things that they had brought up before was that there was a health inspection that, I don't know if it's certified or I don't know what that really means, around how many people were in there or could be in there.
Permit request.
Permit was for 15.
Right, and so it seemed like part of the rebuttal to, because I think we asked that question last time, was, well, there was already that permit there for that 15. So does that permit for 15 officially make it, okay, you can have 15 regardless of whether or not they were allowed to? Because it seemed like my interpretation of the answer was like that validates the fact that that can happen. And I just wasn't really totally clear whether or not that's really the case. Because if that is the case, you know, it changes it, but if that's not the case, meaning like just because they got a permit there prior, like it doesn't really make it acceptable. You know what I mean? Because I still don't see the records, like you said before, prior to that.
Even if you started with 15, the question is, part of the application is that it's supposed to be an effort to bring the facility into less non-conformity.
Yeah.
And we're talking 17 instead of 50. Those are my...
And what was it, again, it was, there will never be more than this amount, but on average it'll be this?
They'll average 15. but
Average 15,
They'll have
okay.
as many as 17.
Okay, thanks.
Greg, are you thinking about the health department approvals? Because the
That-
zoning
That's what
permits,
Greg is talking
yeah,
about.
the zoning permits never specified a number of people. The
Mhm.
record had documentation from the health
Mhm.
department that may have had some.
We do in the record have a permit request that was stamped and paid. It was for 15, and it was from Pivot. Pivot did the request.
To the health department.
And we can grant as a condition, with a condition for a special exception?
Sure.
Yeah, so we could make a condition that no more than 15 people
Well,
will
they don't
reside.
average 15.
I know,
Say
but-
maximum 15.
right, but we could make a condition that only 15 people
What?
reside there.
Reside. There could be 17 there,
And
two of them not really residing there. That's
And-
possible.
would we choose that 15 number based upon that permit that we were talking about? Because I guess that's what I was really questioning, because it almost seemed like that permit was acceptable to say, that's why we have so many, because you approved it in the past, we should be good, where I was more along with, you know, with you saying like, well, should there ever have been 15 in there in the first place? We don't have any records associated with that.
That's my personal observation of the pivot people, but admittedly, that's just one application that I've seen, but I've also heard testimony from the neighbors where they've witnessed a number of people who pivot there also.
Yeah.
Admittedly, it's in conflict with the testimony from the executive vice president that was there.
Okay. Lee?
Well, I still have a big issue with the cost evaluation. In going through the numbers, I think there's $62,000 more in structural work than has been accepted. And
Would you go into that a little bit so that we know?
well, the big number that bothers me and jumps off the page, first off, is the fire escapes.
Absolutely.
Thank you.
That is, and I'm going to make another point about the fire escapes. We have looked at a lot of codes in this endeavor, and I delved into the 2016 Connecticut Fire Safety Code, which is in effect, and this building is categorized as an I3 use. Falls in the same category as prisons and other detention centers. And in going through the various components, one of the things that's required on the fire escapes is that they be covered. Open fire escapes are no longer permitted under the life safety code. So I would contend that Bill Ireland has misinterpreted the life safety code. And in fact, the Connecticut, the fire safety code, that falls also under the purview of the fire department. But, they've tended to disregard it. I have a broader range of the interpretation of structure, and when somebody makes a repair on a roof, which is a structural component of a building, and it costs $2,000, and that repair is not considered structural, I don't believe it. So I take issue with numerous things on this.
Is there just one item for 2,000, or do you have a bunch of other?
Well,
The fire escapes are around 50,000.
yeah. There were exterior stairs on the front of the building, $3,000. Well, you gotta have a structure for a stair. There's stringers, there's treads. That's a structure. And that's $3,000. As Taylor said, the fire escape is the biggest component, and that's structural. You gotta have footings, you gotta have bracing, it goes back to the exterior of the building.
You have to have a professional
Yeah.
design.
They also replaced all the windows in the building. Now, I'll argue that windows are part of the structural element of the building, but they had to put in new headers and new jambs to accept these windows. Those are structural elements. I disagree with the assessment on the structural building cost.
You come up with a total?
The additional total that I came up with was $62,000, which puts it way over the 90,000 that we set as the minimum.
And you have the same concern?
Yeah, I feel the same way about that, particularly the fire escapes. There's a few other minor items in there, but I agree with Lee that there's more structural than I think that have been recognized, particularly with the fire escape.
I would agree with that.
Pardon me, I discussed that.
I would agree with that.
All right, so there is a belief that we're exceeding the 25%.
Also, one of the issues that I brought up earlier is they claimed on the building permit, and I don't have the number in front of me, $320,000 is the cost.
350 and 10.
Yeah, you're right. It's $360,000. Are they going to pay the difference? If they're claiming that there's over $600,000 in the building that they did, they should make up that to the city of Norwalk.
Well, that's only a few $1,000s.
Yeah,
That's
but
minor.
still, I think it shows some premeditation in this.
But subsequently, I guess they have reported to your satisfaction, all the detail that you would need to understand what they did.
Oh, yeah. I agree. I mean, it's there. I just don't agree with the interpretations.
Right. Did you discuss those when you were, those elements in particular, when you were assessing the total cost of the change that did not exceed 25%?
We did not discuss the headers and the windows. We went through the basement and looked there thoroughly. We did agree that the fire escape would be a structural element, but that was it.
So if it was a structural element, was it in that $70,000 or that, the cost that you guys came up with?
Yes.
It wasn't there,
Any further questions?
Yeah, so just to be clear, it wasn't there? Because I don't, maybe I got my math wrong. So what was the, from the building, so you went out with the team and tried to understand how much of the dollars here on some of the invoices they provided were structural. What was the total amount you thought it was?
We looked at the basement and all the 3 floors, and it was, there was no work in the basement, no structural work in the basement.
Mm-hmm.
It was, Mr. Ireland specifically asked questions of the contractor about how the front porch was done, how that was enclosed and what was done there. There was no structural work done to that front porch. We agreed that the fire escapes would be structural and the handicap ramp would be structural.
So,
And then a few other
He didn't
small
think the
amounts.
enclosing of the porch was structural?
He did not.
Again, that would be something I would disagree
I would
with.
disagree with
So
that
what-
also.
can I ask just like fairly straightforward, what's the total dollar amount that, like, did you guys add all that up and say it's X amount of money in structural versus not? Can't remember if that was done.
No, there was just an email saying that they thought that the amount of structural complied with the 25%.
Was under the 25%.
That's the only. I
And
didn't
what
see
is,
it.
remind me, it's 25 of 360, right? So 75,
25
$90,000 roughly?
$91,000.
Okay.
Without being precise at the moment, yeah. So is there
50 of
another,
that is the,
is there another 18,000 or so, 17, 18,000 that's structural that our board members think they
It's
have
not 17,
identified that would be
18,000.
added on and therefore exceed the 25? Possibly, possibly.
It's 50,000, not 17 or 18. No, but you've got the fire
If
escape
you
down
take
to.
this number, you can add them up. Add up to 50. You get It goes over if you then include the larger numbers that we talked about, including, how much of the sprinkler system do you consider to be structural?
He did not consider any of the sprinkler system to be structural. He did, Mr. Ireland did not consider any of the sprinkler system to be structural.
As a mechanical, electrical, plumbing, you probably didn't look at any of that. as
That's
structural.
correct.
So, like-
The way the thing operates is a main high in the house that gravity feeds down, sometimes it's pump fed, but it's pretty big. So when we've had failures in some of the buildings in the city, it's when that main breaks loose, because as soon as it goes under pressure, it starts to shake and vibrate. And so you have to secure it, and it requires changes to the structure. I mean, that just plain does. So it can't be zero. It may not be a huge number, but it can't be zero.
because we're ultimately, like, if we do the math, we're within 5K of 25%.
You did the math on the sheet, or
Yeah.
did you add the other numbers in?
According to this, structural is 36,600, according to what they said. according to this.
Plus the fire escape for 50.
And if you just round off the fire escape to say 50, it still makes it 86,600, which is less. Well, he just said the fire escape, that's.
No, he mentioned 2 to 300.
There was
Specific
repairs
$5
to the
grand,
roof.
$2 grand or something.
Oh, that was 2,000.
2,000. And we've got the front steps.
Well, if the head building official from the city went out and determined what is structural and what isn't, I'm gonna go by what Bill Ireland said. I'm not gonna use my own judgment for that. He is the head building official for one of the 6th largest city in the state of Connecticut, so he knows what he's doing.
Right. I don't know that we could prove that we exceeded, the 25% was exceeded. I think there's a suspicion that it was exceeded, but we can't prove it in one way or the other. And so if Ireland is saying it wasn't exceeded, then that's what we'll accept.
I agree with that.
Any other questions from the board? Mr. Cody?
Yeah, did you want Adam to say, Adam did come, did you want him to, he wrote the report.
If you want to get into the report in detail, I just want to give Mr. Cody a chance to ask questions after all our questions have been answered and your presentations are complete. So if Adam wants to come down and talk to this for a bit, and sit down next to you or stand at the podium, I don't care. But it's got to be specific, not just a wide-ranging discussion about what we do in the city, but it's got to be specific to this application. Is it going to be?
Did you want to add anything?
I'm happy to speak to the ZBA about how ADA.
Adam, why don't you come up and identify yourself and please.
Good evening.
Peter.
I was asked to come to speak about how the city handles ADA reasonable accommodation requests generally. If that would be useful to your discussions and deliberations, I'm happy to speak to that. But of course, I'm only here at the pleasure of the ZBA. So,
Yeah, as long as it pertains to the application that we have before us, and not talking about other things at other times and other places. But if you have a generalized procedure, it wouldn't hurt to share it with us, because then we know what to do.
Could the gentleman just start by introducing himself and his
Sure.
position?
Sure.
I think that'd be very appropriate. My name is Adam Bovilsky. I'm the director of the city's Human Relations and Fair Rent Department. Without getting into anything broad, I will just say that what we do is most of the civil rights related work and homelessness related work for the city. Also in that capacity, I serve as the Americans with Disabilities Act Title II coordinator for the city. That's a required position that each municipality must have. And I'm the one who administers the Americans with Disabilities Act plans for the city. And my background is a legal background. I'm an attorney. So I leave it to the commission. If you'd like me to speak to that, I will, to the application.
You can speak to the application, or if you have a generalized procedure that you use to do reasonable accommodation judgments, either way.
Mr. Chairman, may I just ask a question
Sure.
about the scope of what he's about to say? Again, I'm Tom Cody for the applicant Firetree. In an email yesterday to Attorney McCann, Mr. Bavilsky said, if I were asked to speak before the ZBA relating to the Firetree position, I could not speak specifically to the Firetree petition, as I have not done an in-depth analysis of their petition or ADA arguments. So with that as an introduction, we don't see what could be relevant in his remarks, although interesting, not relevant.
I think a generalized procedure could be relevant, but let me ask Adam now, since you have that, has that changed today for any reason?
I have spoken in some depth with Attorney McCann relating to this particular petition, trying to help him organize and understand how the ADA concepts would apply to this case. I'm more familiar with it now. I can't say that I have an answer to all of the outstanding questions related to the matter, but I do think I can help frame those questions based on my knowledge of the specific petition and my knowledge of the Americans with Disabilities Act.
To be clear, I'd be curious to know if you have had a chance to review the tapes of the 4 evenings of public hearings that we had about the application and the several boxes of documents that we've submitted. Have you had a chance to do that?
Not all of that, sir, no.
We still wouldn't see any relevance to this.
Chairman, if I may, I think what's relevant, and perhaps Adam could just stick to that sort of one point. The questions that I had for Adam were the application of the law. Adam's very familiar with the application of the ADA, the FHA, and the request for reasonable accommodation. What he added and what you've read in his letter, or that he's very aware of how the applications are received, how they're analyzed, how they're individual specific, and how that request is analyzed in terms of the person's disability and specifically the accommodation that's requested, and how those, and the nexus, as he puts it, that he looks for in terms of what their disability is and what they need. And that's where he kind of assisted in this analysis. So maybe he could just say a few things about that. And I don't think he needs to get any more specific than that, really.
Yeah, I don't think it would be appropriate to get more specific other than a generalized approach that you use.
Very well, sir. So an analysis of the Americans with Disabilities Act, under the Amendments Act, we start on a reasonable accommodation request with whether or not the disability claimed impacts a major life function. The law changed a few years ago when it became the Americans with Disabilities Act, Amendments Act, and they greatly broadened the definition of what a disability is. And in most instances, since that change in the federal law, we presume, for the most part, we'll presume a claimed disability does in fact impact a major life function. The next question under the analysis is perhaps critical to this case here, which is that there must be a nexus established between the disability claimed and the accommodation requested. In other words, not referencing this case at all, somebody in a wheelchair asks for a change in a code so they can install a ramp to their house. The mobility disability directly relates to the request, and therefore it passes that test. It would not be true, for instance, if someone in a wheelchair came over and said, I want to not have to pay taxes because of my mobility disability. There's no connection there between the mobility disability and the request being made, and therefore that request could potentially be denied. So in the present case, you would want to make sure that the specific disabilities being claimed relate directly to the request being made, which of course is related to the change or the allowance in the zoning. The next question is whether or not the accommodation being requested will create a fundamental change in the nature of the program or service. There's plenty of case law not relating to zoning. I believe Brian is familiar with it. And then finally, the last test is whether or not there's an undue financial burden and administrative burden created by granting the request, in which case you take a look at both the administrative requirements of granting the request, whether or not that's burdensome on the city, and then secondly, looking at the entire city budget, whether or not the request creates an undue financial burden. So if I'm not going to speak directly to the Firetree application, that would be a general summary of how the ADA analyzes requests.
The last point there on the, was the undue financial
Undue financial and administrative burden.
how does that apply to the surrounding neighborhood. Some of the feedback that we've heard is that I'm trying to sell my home and I can't, or my home was worth X, now it's worth X minus something. Does it extend to that, or is it purely as it relates to the city itself, or?
So specifically the undue financial and administrative burden is just on the city, what the city's cost would be to grant the request, and what the city's administrative burden would be, and it probably would not relate to the issues that are brought up by the community. However, a fundamental change in the program, fundamental alteration of the program, that might relate more directly to conditions in a neighborhood, whether it fundamentally alters the nature of what's going on there.
Does the, just a follow-up question on that. You know, I don't think there's any way to prove this today, but part of the hardship of the neighborhood is that, again, the same example, my house was X, now it's X minus. Does that create a hardship on the city because now we're collecting less tax revenues because this type of thing has been approved or done?
So if you would be arguing that there's an undue financial burden because some home costs in the neighborhood are reduced, you have to compare that then to the city's $300 million annual operating budget. And I think that would probably be yeah, that wouldn't go anywhere, I don't believe.
Okay.
The cost difference would just be way too small to say it's, this financial giant is impacted by the loss of a few $1,000s in tax revenue.
Are you aware if the applicant made any applications to the state building inspector's office for relief from ADA requirements?
I'm not aware of that, but I would not be aware of that, I don't think.
Okay. Then my follow-up question, you wouldn't be able to answer. Thank you.
Did you have anything to add to that? I know that we had tasked you with explaining reasonable accommodation and cabin and going some distance that direction, and how it compares on the case.
Yeah, specific again to that nexus, I'm going to kind of focus on that for a second. That's kind of why I dragged Adam into this, because I could read all the cases in the world, but until you've actually taken a look at a disabled person, asked them questions, got to know their disability, and done some medical research, or some research regarding conditions, you wouldn't be able to put that all together. One of the things that Adam did add to the analysis and the conversation was that I believe in his words, you know, there may be, and please step in if I'm misstating, there may be some literature and maybe even some case law to suggest that recovering alcoholics and recovering drug addicts may benefit from a congregate living situation. But one of the things he had said to me is, keep in mind, when you're talking mentally ill, you can't group those individuals together, and it would not be appropriate to say that all mentally ill people would benefit from congregate living. In fact, he had said to me, there may be some mental illnesses where their situation might actually be exacerbated by living with in a house with 16 other people. So you need to look at those, and that's what he does. He looks at each individual person's disability, analyzes that, makes the connection with what they're requesting, whether it be living in a group home, having a ramp in front of the house, increasing the number of residents from the allowable 6 or 7 to 8. That's what he normally does.
Ladies and gentlemen, if you have any further questions for Adam, ask now.
One final question for me at least. Are you aware that the only space in this building that's accessible is the first floor? And is it unusual that a congregate living facility like this is only accessible on the first floor?
Not necessarily. In other words, first I want to preface this by saying that my expertise in Title II is government ADA obligations, local government obligations. Private obligations are separate. If this is considered a public accommodation, which I'm not even sure it is, it will be covered by Title III of the ADA, so the requirements are quite different. I've looked more to the Fair Housing Code, where new construction is required to have universal design more than renovations. The real question is whether or not their clientele is able to utilize their program fully, regardless of disability, and if they can do that, it's probably passes ADA muster. I'm not going to speak to fair housing.
Thank you.
Mr. Cody?
Can I just ask you, Mr. Babilski, does your department and you yourself, do you review requests for accommodations in public facilities?
Yes, public facilities, yes.
Okay. And when it comes to privately owned facilities, your function is at most advisory, right?
It is exactly advisory, yes.
So it has no regulatory effect or control in a private situation, a private property situation. Is that a fair statement?
Yes, the state code does grant me authority to review that, but the city code actually takes it away and limits my ADA power. So I do not have the ability to, I have no jurisdiction over private entities and the ADA.
So it's fair to say then that everything you've said tonight is not relevant to this application, which is an application by a private entity in a privately owned property.
I would disagree with that, sir, because if this is a program of the Bureau of Prisons, contracted to the Bureau of Prisons, then I would argue that it may in fact be a government program.
It's not, well, I'll have Ms. Ertl correct the record on
Sure.
that, but this is not a government-run facility. This is a facility that's run by Firetree Limited, a 501c3 corporation. It is not run by the federal government. It's not run by the state government.
But any program of the government, right?
It's not a program.
I think there would be a question as to whether or not, because it is contracted by the federal government and it is a program of the federal government, maybe run by the nonprofit, but a federal program, to say it's not a government program, I'm not sure that I would go there.
Thank you.